Hi, I'm Bob Voss, also known as New Business Bob. Welcome to the New Business Bob Show. As you can see, my friend, the patent attorney, Gary Huusko, is with us today. And we're going to be talking about a topic that really does affect a lot of new small business owners, and it's called a provisional patent application, which is different than a patent, right?
It is.
Could you explain to our viewers what is a provisional patent application and why it's important?
Well, a provisional patent application is very similar to a regular non-provisional patent application, but it doesn't require the claims. And actually, when you file it, it's assigned a filing date by the Patent and Trademark Office, and then it just sits there. No examiner will ever look at it, and you have 1 year from the filing date of that provisional to file an application, a non-provisional application, based on that provisional application.
So for a new business owner, if they've got something that they've created and they don't know if there's even a market for this yet, what you would recommend is let's go through the provisional patent application process, get some protection for, you said, a year, right? So for 12 months, and that way they're protected to see if what they have is actually going to be marketable. Is that what you'd recommend that they do?
Well, their protection would start once the patent issues on a non-provisional application, but it would date back to the date of the filing of the provisional application.
Okay, so doing a provisional patent application only sets a date at the United States Patent and Trademark Office that if you then file a real patent, a regular patent application, then that date goes back to that one that you filed the provisional with, right?
Correct, and it's actually more important nowadays because the U.S. has changed to first to file rather than first to invent.
Ooh, wait a minute, what does that mean?
Well, first to file, the world generally used the first to file. Whoever filed a patent application first had seniority rights, I'll say,
okay,
in the patent application process. There are a lot of nuances to that, and an inventor who invented something previous may not be prohibited,
okay,
if that patent issued. But the U.S. office now is first to file, so it's more important now to get your application filed, and even if it's a provisional, because then you've got the earliest filing date.
So prior to that happening, the U.S. wasn't a first-to-file country. We were a, first-to-invent country?
First-to-invent.
And what that meant, the date was really critical, that you invented something. Now, the date is really critical that you file something,
Correct.
Right? So filing is really important. So if you're a new business owner and you've created something that is unique and you want to protect yourself, you need to get a provisional patent application in as fast as you can, because that's the date that the United States Patent and Trademark Office is going to use. Is that correct?
Some type of patent application.
Okay,
either provisional or the non-provisional.
Okay, but a provisional isn't as complex as a regular patent application?
It doesn't contain the claims, and it's, in most cases, much less expensive.
Much less expensive on your time and also at the Patent and Trademark Office, right?
Lower legal fees in drafting it because you don't have the claims to draft, and it's a much lower filing fee as well.
So going back to what I talked about earlier, if somebody's got an idea for an invention and they don't know if there's a market for it, they don't know how big this is going to be, you can at least get an assigned date with the United States Patent and Trademark Office by filing the provisional patent application. Then you can go out and see if it's going to work, if people want it, and then you have 1 year to file the regular patent application, right?
That's correct.
Okay, so if that's really what you should do, can you still put, like you create a product and you filed a provisional, can you put patent pending on that product?
Once you file any type of application with the Patent and Trademark Office, you can put patent pending.
Okay, so if somebody buys something that I created and it's within this year and they see that there's patent pending on it, can they actually find out what I'm patenting? Can they actually read that application?
They cannot.
So that's secret with the United States Patent and Trademark Office.
Right, without the inventors, the applicants, or the representative's authorization, nobody can look at the file. Now, there are ways that you can, but they involve litigation type action.
And that's where they really need to talk to you about
Correct.
this stuff. Okay, so what I think you just said is when you've created something and you file a provisional patent application, you want to put patent pending on that, right? Because that notifies the world that you're actually going through this process.
I always suggest to clients that they put patent pending, but that's it, no serial number
Just the words patent pending on. And that says that you're moving this whole process forward.
Correct.
And so when did provisional patent applications come about? How many years ago was that? Was that like 5 years ago or something like that? You don't know, do you?
I have no idea.
It was a while ago.
It was, yes, a lot.
When you started 17 years ago, there wasn't a provisional patent application.
I don't recall.
Okay.
I don't believe I've worked on one from day one. So
When did the United States switch from a first to invent country to a first to file country?
within the last several years.
Within the last couple of years, right? So this is all relatively new stuff.
new, yeah.
So is the patent law always changing? I mean, do you get notified of changes every year?
Things will change, but not necessarily the patent law.
Okay.
Now, there was the big change.
A couple of years ago
Right.
when it did that. Okay. Thanks for being here. I really appreciate that, because people, as they create new products, you need to be thinking about this provisional patent application. This may be your first step when you go to a guy like Gary Huusko or any patent attorney and talk to them, and they will advise you that this may be the first thing that you need to do in order to protect what you have created. Thanks for watching this video. Thanks for watching the New Business Bob Show. And I really thank Gary Huusko, the patent attorney, for being here answering some of these questions. Thanks for watching.